Welcome, everyone. I think we'll get started because we had a full agenda when we began planning for this, and now we've gotten even more information to pass on and to discuss. This is the Supreme Court and state immigration laws, to make sure you're all in the right place here. And I want to welcome my panelists. And before we get rolling and I introduce them more, I thought just a couple bookkeeping things. Remind everyone to turn off their cell phones, and panelists also, and I will get to mine in a second, because actually they interfere with the microphones for the feeds. And just so all of you know, we're going to be leaving at least 20 minutes for Q&A, and when that does begin, before you ask your question, please find the microphone, and the folks from ACS remind all of us that questions should be both short and actual questions. And then we'll finish right away at 1:30, and as we get closer to that, I'll let you know what the next panels are. Our main order of business, of course, is the Supreme Court case that's pending, Arizona v. United States. But because we have some news today, we're also going to segue toward the middle of our discussion into the news from the Obama administration. And I'll just tell you, I think probably everyone in this room at least has heard a part of this, but I should let you know that Secretary of Homeland Security Janet Napolitano announced that effective immediately, certain young people who came to the U.S. as young children, I think it's under age 16, and who meet several criteria, will not be deported. It's the Obama administration taking moves in an executive manner to implement the DREAM Act. And we'll be discussing that, and I think later today, in a way that does not conflict with what we're doing, the President and others will actually be holding news conferences. We're their warm-up act, so to speak. Joining me today are four people who have deep experience in the immigration field. Their full biographies are in your materials, but going from my far left and in alphabetical order, we have Representative Stacey Abrams, who's House Minority Leader in the Georgia General Assembly. Georgia, as you know, is one of the states that has actually passed a law sort of trying to copy what Arizona's SB 1070 did. Next to her, further moving over to the right, but not, yes, to the right, is Utah Attorney General Mike Shurtleff, who actually has, Utah also passed a law, and it's gotten sort of caricatured in some ways as being identical to the other so-called copycat laws, but he will make some points about how it is different, even though it's also been enjoined in parts, and sort of talk about the competing policies there in Utah. Then we have Maria Elena Incapié, who's the Executive Director of the National Immigration Law Center, whose people are very much active on the ground in all states, and particularly in Arizona, trying to challenge these laws, and who will have a broader perspective of how, however the court rules, it will play out on the ground. And then to my immediate left is Lucas Gutentag of Yale Law School and Stanford Law School, and whose roots are very heavily in the civil liberties community. He helped found the ACLU's Immigrant Rights Project, and he will be offering lots of perspective, both in terms of what the court's going to do, but also how this fits into this moment that we're at that clearly is heightened by what the administration did today, and will certainly be further ignited by what happens with the Supreme Court. As most of you know, Arizona versus the United States was heard on April 25th, which was the last day of this, the court's oral argument session. And the ruling is likely to come the last week in June. I'm predicting that, even though it could come as soon as Monday. But as many of you know, several other big cases, not just healthcare, not just Arizona immigration, are still pending before the justices. They're going to be in on Monday, and they'll be in on Thursday also. The key question before, first of all, the law signed by Republican Governor Jan Brewer on April 23rd, 2010, requires police officers to ask for documentation if they have, quote, reasonable suspicion that someone they've stopped is here illegally. It would also make it a state crime to be present in the United States or seek work without proper documentation, and it allows the arrest of people believed to qualify for deportation. The key question before the justices is whether Arizona or any other state has authority to institute these immigration policies based on just the respective roles of the federal government and the states. We're going to talk a lot about the kind of civil rights and racial profiling potential of these kinds of laws, but the actual question before the justices is sort of quite dry and has to do with the structure of government. Does federal law preempt states from doing this? As you know, lawyer Paul Clement, arguing for Arizona on the 25th, contended that, first of all, Arizona is a border state that bears the disproportionate cost of illegal immigration, and that in terms of preemption, Arizona was working cooperatively with the federal government, not trying to supersede it. Don Verrilli, the U.S. Solicitor General, who argued for the Obama administration, says, no, look, the U.S. has, the federal government, national government, Congress has exclusive authority in this area, and Arizona can't try to write its own policy. And in effect, what it was trying to do was drive out illegal immigrants. Now, Chief Justice John Roberts, I'm just going to make two short points before we get to the reaction. Chief Justice John Roberts went out of his way to say that this doesn't have to do with racial profiling. And before S.G. Verrilli could even get his first full sentence out challenging the law, said, before you get into what this case is about, I'd like to clear up at the outset what it's not about. No part of your argument has to do with racial profiling or ethnic profiling, does it? Now, I thought that was sort of interesting to have him sort of testily go in like that, but it does show that they want to make the point, the justices, or at least the chief, that they are not in a position to endorse something that could potentially be discriminatory. That case is also coming up the pipe, and we'll talk about that. Another point I want to make is that this case was heard by just 8 justices. Elena Kagan, President Obama's most recent appointee, former Solicitor General of the United States, had been involved in an early stage of litigation. So I think the best betting is that we're looking at potentially a 5-3 ruling, as we had in the Chamber of Commerce Whiting case, a similar preemption issue that came a year earlier. But that's just to lay out some of the general information about the case. And we're going to turn first to Lucas to talk about what his takeaway was and what you think we might be headed for in terms of a ruling and how it might play out. And also let people know about where you're coming from on this whole issue.
Okay, thank you very much, Joan. And with that great overview, and with all of you, many of whom I think are very familiar with this, what I thought I would do is maybe just review very quickly what the particular issues are that are before the Supreme Court, because it is just technically a preemption case in the sense that this is only the United States challenge to the Arizona laws. Maria Elena will talk about the United States brought suit against Arizona after the ACLU, the National Immigration Law Center, the Mexican-American Legal Defense Fund, the NAACP, and a whole coalition of civil rights organizations sued against the Arizona law on federal preemption and numerous other grounds. The United States has asserted only its own interest that the Arizona law is preempted. And because of the way the litigation proceeded, the injunction issued by the district court and the injunction affirmed by the Ninth Circuit, it was only in the United States suit, but the civil rights suit continues in district court and continues to raise many other claims. So having said that, the issue before the Supreme Court was whether 4 particular provisions of the Arizona law were preempted as a matter of federal law based on basically the Immigration and Nationality Act, the federal structure regulating immigration, and whether the Arizona law interfered with the federal prerogatives and priorities and primacy with regard to immigration. So in particular, the provision that got the most attention, the one that Joan just mentioned, is the so-called show me your papers, or what I call the detain and verify provision, which is to say that Section 2B, and if you read the oral argument transcript, or if you're, once the decision comes out, the heavy focus at oral argument was on this particular provision, the show me your papers. And that's the one that provides that if a police officer in Arizona stops a person for any reason, then the police officer must, if the police officer has reasonable suspicion that the person's undocumented, must require the person to verify their status, and the person must be detained until the federal government has verified that person's status. So what that means as a practical matter is that if there's any arguably legitimate basis, and I know Stacy can talk about this, what that means. If there's any arguably legitimate basis, or I think any pretextual basis, you've asked me to give my own views on this, right? Any pretextual basis for stopping anybody, then the police officer must detain the person until their status can be verified if, in the unfettered discretion of that police officer, there's any reason to believe that the person might be undocumented, which of course necessarily, inevitably, in my view, leads to discrimination and profiling, and that's why this is, in fact, front and center in these cases. The issue of profiling cannot be divorced, and in my view, even from the federal preemption claim, can't be divorced from how this statute will operate. It will necessarily and inevitably lead to discrimination and detention of persons based on their ethnicity, their appearance, their language, and so on. So that's the Section 2B. That's what got the most attention. But there were 3 other provisions at issue also that the court's going to address, and this is kind of a long way of saying I think what we're going to get is a complicated decision dealing with each of these provisions separately, and I can also imagine different justices lining up differently with regard to the different provisions. So we've got 8 justices addressing 4 different provisions of the statute. Based on the oral argument, the federal government's legal challenge to the Section 2B, the one I was just mentioning, the stop and verify, the show me your papers provision, that challenge as a facial preemption matter did not generate a lot of traction, in my view. There was concern about it. There were a lot of questions about how it would operate. There were questions about how long a person might be detained, but it didn't seem like there were a majority of justices who were likely to enjoin that provision as a facial matter. Now, I just want to preface all of this with the obvious. Making predictions about what the court's going to do based on sitting in the courtroom, listening to the oral argument, and having read all the briefs, that's a dangerous enterprise that I don't usually engage in, but everybody's asking me to give you my sense of it, so I'm happy to do that. But I think, you know, what I say is worth about as much as it costs to send an email to your friend about what's going on in this room. So anyway, so that's 2B. The 2 other provisions that got some attention are provisions that make it a state crime, create new state crimes. One of those state crimes is it's a state crime to engage in or to solicit work if you're not authorized to work. So in other words, for an undocumented person to seek work that's not authorized, that's in violation of the Immigration Act, or to engage in unauthorized work, that's a state crime under Arizona law. It's not a federal crime to engage in unauthorized work. There's no federal criminal penalty for a person to engage in work without authorization. There are lots of provisions that penalize employers for hiring undocumented workers, including crime. It can be a crime for an employer to engage in a pattern and practice of hiring undocumented workers, but nothing in the federal statute criminalizes the alien for engaging or seeking unauthorized work. So in my view, that's kind of the most radical departure from the structure of the Immigration Act for Arizona to make a crime out of seeking or engaging in unauthorized work. That got a little bit of attention, not a lot. The other provision makes it a state crime to violate the federal registration statute. And that's more complicated, but basically there's a federal registration statute that makes it a misdemeanor for certain people not to have immigration registration documents. Arizona's created its own its own state criminal scheme that they argue tracks the federal scheme. I think it doesn't. The United States of America doesn't think it tracks the federal scheme. But so those are 2 state crimes for immigration violations. I would say that it seems like that's the provision, the Section 3, the state registration crime, that seemed the most vulnerable based on the oral argument. The work authorization crime also seemed vulnerable based on the oral argument, hard to read. Different people have different views on that. And then the 4th provision got virtually no attention. That gives police officers in Arizona the authority to engage in warrantless arrests of people who have committed deportable offenses. It's further arrest authority based on having committed a public offense. It didn't get much attention. I think it's derivative of the other provisions, and it's hard to know what's going to happen with that. So coming out of this, I would say that, as Joan mentioned, there was a desperate desire on the part of at least the Chief Justice to avoid any sense that the issue of racial profiling and discrimination is presented in the federal preemption case. I think that's mistaken. I think, as the Solicitor General subsequently said, harassment of foreign nationals is in fact one of the key reasons why the Supreme Court has said that federal authority it preempts state law, that the threat of harassment of foreign nationals is the reason why states are prohibited from engaging in immigration enforcement. And so in fact, that does present that issue through the preemption lens. That didn't get developed at argument, and I don't know whether or not it will be addressed in the court's opinion. So I guess to summarize is I think we can expect an opinion that will go through each of these provisions point by point. The alignment of the justices may differ on the different provisions. The ones that are the most vulnerable, it seems to me, are the ones that make it a state crime to those two provisions that create new state crimes, and the provision, the stop and verify, the show me your papers provision as a facial matter seems unlikely that the preemption claim against that provision is going to garner sufficient votes to strike it down.
Thanks, Lucas. After we go through these introductory remarks, we're going to come back and all of us sort of discuss sort of if we have a mixed ruling like that, what are the consequences, who's the real winner, who's the real loser. But first, let's turn to Maria Elena to talk about how this actually plays out on the ground in the states where you've been and where your people are. And just in light of that, in addition to having big news today, we also actually have a big anniversary today. It's the 30th anniversary of Plyler versus Doe, which, as some of you remember, was the June 15th, 1982 case written by great liberal William Brennan that ensured that irrespective of a child's parents' status, illegal alien or not, undocumented worker or not, the child was entitled to a free public education. In that ruling, Justice Brennan wrote for five members of the court that it would not tolerate the creation of an underclass in society, one permanently oppressed by the denial of free public education. And I know you want to salute that ruling as well as talk a little bit about what the court action might mean on the ground.
Great. Thank you, Joan, and thank you all for being here. It's not every day that I get to be on such an incredible panel with my board member, Lucas, one of our defendants, Attorney General from Utah, and one of my favorite policymakers in the country, Stacey. So thanks again for being here. You know, we are living in a really momentous...
Just waiting my turn.
That's right. And he's, you know, one of the best defendants we have. So we actually agree on a lot of things.
It's all good now.
That's right. We actually agree on a lot of things. We only sued one of the bills, one of the 4 bills that they enacted. So as Joan just mentioned, today is a really incredible day. So not only are we celebrating the 15th anniversary of the Plyler decision, which is a really important decision in our history because this is about the Supreme Court having recognized in Plyler that every child in this country, regardless of their immigration status, has the right to primary and secondary education, and that as a country, we shouldn't penalize students and instead should invest in them so that they can become full participants of society. When you fast forward to today, it's such a different context in which we're looking at immigration policy. And in fact, today, the Time, how many of you have seen Time magazine today? Okay, you need to pick it up. So I actually had meant to bring down my copy. The Dreamers, so undocumented immigrant youth, are on the page of Time magazine today. And it's a really beautiful article written by Jose Antonio Vargas, who is a dreamer himself and a Pulitzer Prize journalist, who basically talk about we are American, right? We've been here. We are just like one of you, and we want to contribute to society. We just don't have this piece of paper that Congress has not passed the law for us to have and become citizens. So they are citizens in waiting. They are Americans for every stretch of the imagination, with the exception of not having that legal status. And then today, as Joan mentioned, the Obama administration has just issued a policy change, which again is really significant. It will make such a difference in the lives of dreamers around the country. And I start with that because actually Dreamers are some of the people who will benefit. They are some of the people who were at risk of being detained under laws like Arizona's SB 1070. So as Lucas mentioned, the National Immigration Law Center, along with a broad coalition, civil rights coalition, we filed the Friendly House case back in 2010. We filed it first before the Department of Justice lawsuit. And in our case, we have, in addition to the preemption claims, we also are arguing that SB 1070 should be struck down in its entirety because it violates the First Amendment, Fourth Amendment, Fifth Amendment rights, Equal Protection Clause as well. Our case is very grounded, in fact, on the racial profiling provisions, and I will explain why in a minute when I talk about Alabama, which is the first law that actually has been implemented, and so it's a good example of what awaits us in Arizona, depending on what happens with the Supreme Court. But I think, as both Joan and Lucas have noted, one of the things for me that struck me from the oral arguments was this comment and question by Chief Justice Roberts right at the get-go of really wanting to control the discussion and the oral arguments so that the Solicitor General didn't go into how SB 1070 affected racial and ethnic profiling. And I think the reason for that, frankly, is that Arizona's SB 1070, just as Utah's, Georgia's, Indiana's, Alabama's, and South Carolina, and Georgia, I don't remember if I mentioned it, they cannot be implemented without racial profiling. In fact, one of our main proponents, spokespeople against these laws is the chief of police from Burbank from Salt Lake City, Utah. We've seen the impact of these laws in Arizona. We've seen many, many people who are being racially profiled. One of our plaintiffs, Jim Shee, is a elderly man of Chinese and Spanish descent, a U.S. citizen who has been stopped and detained because the police did not accept the driver's license that he had from Arizona because he doesn't look Arizonan, whatever that means. In Utah, for example, one of our main plaintiffs is a dreamer by the name of David who was also racially profiled on the way to Bible school and detained. And he is somebody who I'm so happy about today's announcement from the administration because this plaintiff would potentially benefit from this new provision that the administration, this new announcement from the administration, at least to not be deported. In Indiana, Georgia, South Carolina, and Alabama, we also filed suits afterwards when each of those laws were passed. As you may know, in September of last year, with our Alabama lawsuit, the district court actually decided not to block most of the provisions. Alabama's law goes beyond, I would say most of the laws are copycats of SB 1070, with the exception of Alabama. Alabama goes far beyond. It affects every aspect of people's lives, in addition to the requirement of verifying individuals' immigration status. It also prohibits, it actually required verification of the status of children K through 12, which flies in the face of Plyler. It also prohibited the enrollment of students in higher education, whether they were undocumented or lawfully present. That actually has now been fixed by the legislature recently. In addition, in Alabama, if you enter into a private contract with somebody who is undocumented, that contract cannot be enforced by the state courts. Just think about that from a contracts law perspective. That affects every aspect. That's about renting, leasing an apartment. It's about selling a car. It's about an employment contract, which is one of the ways we've seen this. Employers basically telling workers, I'm not going to pay you because if you go file a lawsuit against me, our employment relationship isn't going to be enforced by the state. The Alabama HB 56 initially also included made it a felony if an individual engaged in a business transaction with any part of the state or municipal governments, and that was initially interpreted to also include the denial of water. Again, just think about this from a fundamental human rights perspective of the ability to actually get water in your home, to be able to feed your family, the ability to get electricity. All of that initially would have been considered a felony. And we set up an emergency hotline immediately after the decision came down with the legal team. Within the first weekend, the decision came down on a Thursday. Within the first weekend, we had 1,200 phone calls. with a range of callers. To this day, we've had about 6,000 callers. Now, mind you, Alabama only has about a 4% of foreign-born individuals, and that is all foreign-born, not undocumented. The school system, 97.9% of the students are U.S. citizens. So this law is really about a hate and racially charged law about people who are really trying to take the country back. And Alabama, unfortunately, has a history that knows very well what structural racism is about and what exclusionary laws like HB 56 are. I must say that recently, as the legislature tried to fix HB 56, they tried to tweak it and amend it. One of the reasons they did so was because among the people that were racially profiled under HB 56 were two executives, one from Hyundai and another from Mercedes-Benz, who were detained by the police, again, because they were not able to prove their status. Unfortunately, the governor got a call right away, and they were able to get released, but that has been fixed. But most people of color in Alabama are being impacted by this law. And in fact, the NAACP has started to say that they have seen an increase in the number of African-American males who've been detained and who've been stopped under this law since HB 56 went into effect. Not a surprise. And so again, there's no way that any of these laws can actually be implemented without racial profiling. And in fact, when SB 1070 was first passed, even Secretary Napolitano herself expressed that statement, that there was no way you can do this in a racial neutral way. So there's a lot of concern about the impact that the Supreme Court decision will have. As Lucas said, I am not even going to try to guess at what the decision is. We've done a lot of analysis, are expected the decision any day. The big concern is that this will result in state-sanctioned racial profiling and the impact that that will have on survivors of domestic violence who will be afraid to come forward and report crimes. We already have seen that reported every single state: Arizona, Indiana, Utah, Georgia, South Carolina, Alabama. We have received call after call from advocates saying, I have somebody who is living a really horrific either sexual abuse. We have a plaintiff, a Jane Doe plaintiff who was raped. People are not willing to come forward to report these crimes. And that, from a public safety perspective, is one of the reasons that law enforcement has been so concerned about these laws.
Thank you, Marilena. General Shurtleff, your law is different in some ways, and as Marilena said, only one provision was actually challenged. Why don't you try to explain from your point of view how it's different and what the competing policy interests were in the state?
Thanks, Jonah. If I could just mention on the other broader picture, I did have dinner a few weeks ago with Paul Clement. Had a chance to kind of get his analysis of how he thought it went, having argued 59 or 60 times before the Supreme Court. His analysis was basically the same as we just heard from you, Lucas, and he's, of course, they're reading.
I'm not usually in the same company as
I know,
Paul, but
I know,
that's okay, I'll take it.
As far as trying to, if anybody can try and read the court, kind of the questions and what was going on, I think, seems pretty fair and concerned. Look, if you thought I was going to be, because I'm the controversial, I wasn't planning to, but I think I will a little bit in this sense, and that is that I've said over and over again as I've crossed the country trying to get states to, if you're going to pass legislation because the federal government has failed in their responsibility with regard to comprehensive immigration reform, then it ought not to be tough, enforcement only, drive them out at all costs kind of legislation, and that there ought to be alternatives that we can pass that's more just and comprehensive and pragmatic and fair and compassionate, et cetera. And so what I've noticed in my discussions and why these states tend to be passing enforcement-only type legislation is because the greatest casualty in discussion so far has been the truth, and that is these laws are passing because people are misrepresenting the facts and suggesting that we're under invasion, that the large majority of Latinos, the majority are violent criminals, that they're taking away jobs. All the lies that are being told, but they're the basis for these tough enforcement only because people are scared and they start believing all of this. So I'm trying to tell the truth about that, and that outrages me that they're being told that. And I'll say, after you were so nice to me, I will say that I have the same problem on the other side, that if for whatever reason you misrepresent what other states are trying to do, like Utah, and lump us into the same category, And to say that our law just flat out is cannot be enforced without racial profiling simply misstates the fact of Utah and what we tried to do. And I think that handicaps our ability to convince legislators, particularly Republicans in other states, to do something different. Because no matter what you do, you know, and you don't pass an enforcement-only horrible piece of legislation like we've seen in other states, you're going to be sued anyway, and you're going to be lumped in, you're going to be vilified. And that's going to scare them away for trying to do something that's right. And so I do want to make a statement. In Utah, we, beginning in April 2010, after 1070 was passed, because word of the North and all the fear was, from these legislators, was that we're going to have this influx of illegals, of undocumented aliens, illegals in their words, from Arizona, that we had to do a copycat. And in fact, 1 month later, we had legislators who had that bill ready to go in Utah. Our session starts in January. And because I'm a chief law enforcement officer, we were very concerned about what Arizona 1070 did. I had grave concerns and shared your concerns of racial profiling based on reasonable suspicion and stop anybody anytime. And if you don't do this, if you don't have a policy, if you're not enforcing, the people can sue you, which would make it even more onerous on law enforcement to get out there and try and make more stops and question more people. So we in law enforcement said we've got to do something, but we understood at that time we couldn't just say no to 1070. If that was our plan, just say no to 1070, we would have lost, and a 1070 law would have passed in Utah. So we had to come with something to offer it differently. And we had to do what we could to pick apart, we as lawyers trying to convince the legislature not to go that route, and look at the Arizona law and the most objectionable parts of it and take them out of our law. So we took out any stop, any time. We took out reasonable suspicion. This is in Utah, if you are stopped based on probable cause that a crime has been committed, a felony or a Class A misdemeanor, which is a serious classification of misdemeanors, if you have probable cause for a stop, a crime has been committed, then you ask for identification. If it's me, you, anybody, doesn't matter who you are, that's what we do in law enforcement. I'm arresting you for breaking the law, I got to know who you are. And if you can't identify who you are, then they're required at that point to try and determine what their status is. Substantially different. We took out private right of action so they could sue. We made significant changes. Now, I still opposed it, by the way. I opposed it. I still thought we shouldn't have any, but understanding it would go forward, we tried to do the best we can to fix it, and then to pass other types of legislation we may talk about later, work permit and so forth. But we do believe, and because ours is substantially different, that our law is going to uphold any challenges that might go forward. One thing we do know, and that Paul Clement, I think everybody agrees, the result that we will have from the decision, no matter which way it goes, is plenty more legislation around the country and a whole lot more litigation, which for lawyers, I guess, is good. I don't know, but not so good. That's what we can look forward to because people are going to go forward now. And so what we're trying to do, I'm trying to do, is take Utah's example and say, states, yeah, if you get a green light from the Supreme Court that you can start making every cop out there an ICE agent to do these things, that is very, very harmful to the overall picture of public safety. And we will continue to fight anybody doing that, but we want to offer alternatives and would request a little bit of recognition that you have to sometimes, you can't just say no and it's going to continue to pass and be in litigation for 5-6 years. We got to do something different and try and convince not only states, but hopefully, ultimately, U.S. Congress to do the right thing on comprehensive immigration reform.
Thank you. Thank you very much. Stacey, now Georgia didn't go in the direction of Utah to try to temper it. It went the opposite way in many ways. Why don't you talk about your law and just how it unfolded and just where it's at right now and what you're looking for in the Supreme Court ruling?
Certainly. We decided that we wanted to be worse than Arizona, but Alabama beat us. And we let them win when they can. So ours, we essentially followed the Chris Kobach Arizona model. So we did Show Me Your Papers, which of course has a very specific resonance in Georgia. Our capital actually sits on the corner of Capitol Avenue and Martin Luther King Jr. Drive. And there is an irony that misses everybody in that building often when we pass laws that literally return us to the 1800s in Georgia. In Georgia and a lot of southern states, traffic offenses are crimes. So not just driving erratically, but speeding, failure to yield, lane change, jaywalking. These are all crimes. These are not traffic offenses where you get a ticket. You actually can go to court. And so, unfortunately, we don't have the nuance that I think Utah tried to achieve. The way ours is set up, any law enforcement officer has the ability to make up a crime, to say that they saw you swerve, they saw you cross the street, and I have a great deal of respect for our law enforcement officers, I really do. But I used to work for city government. There's a great deal of pressure when a law is in place to try to make sure you're doing your job, and there's even more pressure in certain communities. When your population change, it's not only changed in terms of numbers, but in terms of color. We have communities where communities of color are under attack. And this gives those who are not as well-intentioned as others a new tool to use, and that's a very dangerous thing. Georgia also decided that we were going to get into the trafficking business, and so we have 3 components of our law. One that says that it's illegal to transport a person who knowingly transport a person who is undocumented. The question is, how do you know? There's no definition, there's no threshold, there's no test. If they look different, maybe you should know it. And so that's a crime, and it's a misdemeanor if you have fewer than 7, but if you have more than 7, it's a felony. There is also the issue of harboring. So if you have an apartment building and you rent to somebody whose name doesn't look like Jones or Smith, you run the risk of violating the harboring law. If you are a church that has a homeless program, if you know that someone in your dominion is possibly undocumented, then you run the risk of committing a felony. And then there's also one of assisting in entry. We don't know what that means. Does it mean enter the country, enter the state? We weren't really precise about what we wanted that to cover. So there's a great deal of fear about enforcement, because essentially anything you do, if you aren't overly vigilant about checking someone's status, you as the person either driving the cab, renting the car, serving meals, or transporting a group to church, you run the risk of violating and committing a felony. We also decided not to use the Arizona model of creating a state crime for work. What we did instead is make it a felony punishable by $250,000 fine and 15 years in prison for having an ID that is not true. So if you use your ID to get a job, if you are over 21 and you do so, over 18 and you use a fake ID, you can go to prison for 15 years. So imagine, not only the example of the woman who has been abused, but imagine a woman who gets a fake ID because she's hiding from her husband and she's trying to build her life. She is now facing 15 years in prison and $250,000 fine. That is longer than most of our economic crimes. And the only thing you have to do is have a fake ID. If you are in college in Georgia, be really, really careful. We also faced fairly substantial blowback from this. Georgia's largest single industry is farming. We're an agricultural state. 12% of our GDP comes from agriculture, almost $16 billion. We faced, in the 6 months between the adoption of the law, it went into effect July 1, 2011, between July 1 and December, $300 million in crop losses. And that happened because you could not get laborers. And because Georgia is part of a circuit for migrant farm labor, when people didn't come to Georgia, they then didn't go to Florida. They didn't go up the coast to North Carolina. They didn't go to pick blueberries in Maine. They didn't go to Michigan, and they didn't go to California. And so the disruption in the migrant farm labor is a disruption for the entire nation. This is not a contained issue, and I think that goes to the question of local preemption. States, we are not isolated, despite our best intent. We are part of an ecosystem that literally can cause the rest of the world hundreds of millions of dollars. And the fear that I have is that we didn't look at this in the context of the Farm Bill that's out there. The Senate version of the Farm Bill is going to essentially handicap Southern farmers who do mechanized crops like peanuts and cotton. Sounds really, to anybody who doesn't care where their GIF comes from, you wouldn't worry about it. Except that the only way to deal with migrant farm labor shortages is to move to mechanized crops. Well, if you can't move to mechanized crops because you can't get the early investment because we've changed the financing system, then you run the risk of having a depression across the board in our agriculture. That then means that your stores are selling things at a higher price. That means that your local communities can't fill their food banks. There are these ripple effects that happen because of very basic decisions that we're making at the state level, and we're making those decisions, and having sat through, I serve on the committee of purview, I serve on judiciary and non-civil. I sat through every single hearing, I sat through every hour of debate, and there is an animus that undergirded this bill in a way that I've rarely seen at the Capitol. And it's the nature of politicians. When troubled times come, you find someone to blame. And immigration has always been the fallback position for politicians who couldn't explain why they couldn't create jobs. If you look at the Alien Exclusion Acts, if you look at what California did, you go to New York, every state at one point or another has to find someone to blame for their woes. And in the South, we tend to like color as one of our markers of anger. We're really good at it. It's one of our practices and habits. I think the challenge is that because of the changing demographic in Georgia, we are actually one of the fastest growing states for the Latino population and for Asian populations. Georgia is also one of the I think we're 8th or 9th in terms of refugee resettlement. So we don't just have your standard Hispanics and blacks. We now have Bangladeshis, and we have people who speak languages you've never heard of, and they live in your community. And that has caused a great deal of tension because these are communities that pride themselves on being fairly homogenous. And they wouldn't characterize it that way. You talk about being, you use other code language for it, but essentially we seek homogeneity in a lot of parts of the state and a lot of parts of the South, and that's being disrupted by immigration. But it's also being disrupted by birth. We have lots of second generation and third generation communities of color that have not existed in the South in a long time, and that has created a great deal of tension and anxiety. We saw that play out in the redistricting maps that we had in our this electoral cycle as well. And I say all that to say that the fundamental issue at stake here, and I think racial profiling is the cornerstone of it, but the real core issue is that the United States does not look the way it did in 1954, and some people are really unhappy about that. And my only answer is get over it. I'm African American from Mississippi. I grew up there. I grew up in a community that has one of the largest Vietnamese populations in the U.S. because of when, at the end of the Vietnam War, a number of Vietnamese were airlifted into Gulfport. I grew up expecting there to be different looking people around me, which is not something that Mississippi is known for cultivating. I moved to Georgia, the more progressive state, and find myself in the legislature at a time when we're not making progressive decisions. And I don't mean progressive politically, I mean progressive in terms of acknowledging the changes to our society. The other piece is, if you look at the panel, you don't often find African Americans touting changes to immigration policy, except for the guy down the street at Pennsylvania Avenue. But I think it's critically important that African Americans be a part of, especially African American politicians, be integral to the conversation about immigration, because this is a human rights issue. This is a civil rights issue. And I return to my statement about sitting at the corner of Capitol Avenue and Martin Luther King Jr. Drive. To be in a space that has his portrait hanging there, and to make to condemn communities for simply not looking the way we expect them to look, for not speaking the language we expect them to speak. That is how bad things start to happen. That is how we erode the fabric of our society, and the extent to which we allow individual states to pick who we want, to decide who can live here and who cannot, whose rights should be protected and whose rights should be ignored. The minute we decide that justice is just for us and not for them, we become the nation state that we decry when it happens across the sea. And so I'm very adamantly opposed not only to HB 87, but to any laws that seek to create the ability for states to individually pick who they want to have in their midst.
Thank you, Stacey. I'm going to ask the panelists about the core racial profiling issue and training, and talk about police training and how what can be done in states, since there's still a problem, and what can be done in states that avoids racial profiling. But first, since many lawyers are in this room, I want to ask Lucas about, when we all get the ruling, how we look at the preemption attack that the justices make? What, if they, are we in a case right now where they could essentially cross a line in terms of their interpretation of preemption that does maybe only uphold 2B, but yet because of the analysis essentially invite more laws like this? Or did we already pass that with the Chamber of Commerce versus Whiting case last year, where the justices by a 5-3 vote upheld an Arizona licensing law against a similar preemption attack? So are we at some sort of threshold here on that?
So that's a really good question. And the only thing harder than predicting what the court's going to do is analyzing the opinion before it gets issued. But
do your best.
I'm going to try.
Good. Yeah.
So here's what I think, because I really do. I think it's a really good question, and I think that it depends on how the court rules, and by that I mean how doctrinally it analyzes these 4 different provisions, and here's why I think that matters, because in the argument that Arizona made, basically in some parts was to say simply that what we're doing is authorized by federal law. So for example, with regard to this, the 2B, the stop and verify, the state of Arizona in part argued, using the Whiting decision from last term, there's an authorization in federal law that allows police officers to engage in this kind of conduct. There's a so-called quasi-savings clause in 287G10 that says, and police officers can do, it lays out all these ways in which police can operate under federal authority. Local police can operate with agreement with DHS, and then it says, and police can cooperate in other ways. So Arizona is saying, well, that says that our police can do all these other things, and there's actually federal authorization in the statute for us to do this. But the United States argues it's not cooperation if we're asking you not to do it, and you're doing it anyway. And so then, so as to that part, it really depends. Is the court going to say, you know, you can do whatever you want, or is it going to tether the permission to this particular provision in the immigration statute and say, so therefore it's implicitly authorized? You know, so that's kind of, while the implications are huge because it's going to lead to the kind of discrimination that we're concerned about and the profiling, the legal analysis could conceivably be relatively narrow. As to the other provisions, and I go back, for example, to the provision about criminalizing unauthorized work. And the reason I said in some ways that's maybe the most radical argument, doctrinally to me, that seems like if the court authorizes that, it would be kind of turning the immigration statute on its head. It would be saying that anything that's not prohibited by to the states by federal law is free game. So states can go around and look, any little blank, it would turn the Immigration Act, instead of a comprehensive scheme, into kind of this lattice work. And any place where a state can find an empty spot, it could say, okay, well, so we'll fill that and we'll do whatever we want. So that one, to me, I think, if they uphold the work authorization one, seems to me to raise the prospect, the crime, of having kind of the most radical doctrinal, and that, I would think, does cross a line. The federal registration provision, it depends on how they read a 1940s case about the federal registration scheme displacing all other state alien registration laws that used to exist. But I think, again, that one has more radical implications because it would allow a state to create a crime that's not part of the federal scheme, to create add-on penalties and to essentially create its own regulation. And if I can't, so I think it really matters how each provision is analyzed and whether it's tethered to a mistaken view, in my opinion, but nonetheless a view by the court that it's authorized by federal law, or whether it's acting in a vacuum and therefore it's permitted. And if I, oh, go ahead.
No, I was just going to say it's helpful because I think for many of us who will be reading it and trying to either translate it for media purposes or translate it for clients or for people on the ground in Arizona, it's not just what they do on the individual 4 provisions, but how they do it going forward. So go ahead. No, add your other point before.
I wanted to add a couple of things, which is, one, I think what's lost in all of this, and Mark, I think, really alluded to this, and I want to both kind of quibble with you and compliment you, if I may. But what Mark, there's nothing secret about what these laws are designed to do, and that's one of the things that got lost in the argument, gets lost in the discussion. The first part of the Arizona law says our policy is attrition by enforcement. We have our own immigration policy. What we want to do is drive people out of the state, and they're not being secret about that. That's their intention. That's what they want to do. And then attrition by enforcement, what does that mean? We want to make life so miserable for aliens that we don't want that they will leave our state. Where will they go? Maybe they'll go to Utah, maybe they'll go somewhere else. That's not our problem. We want to drive them out of the state. And the attrition by enforcement, as the brief filed by New York and a bunch of other states supporting the federal government's challenge pointed out, this is not some secret term. This is the terminology used by restrictionists. What does attrition by enforcement mean? Go after neighbors, go after family, go after communities, so that undocumented people will not have any place to be. And we don't care if those families, communities are documented, undocumented, citizen, non-citizen. We want to drive people out of the state. You know, that's the policy that underlies it. So in that respect, to allow the state to do anything is to create this dangerous environment. And in that respect, should I start just with the quibble? Because I really want to compliment what Mark said about there's so much misinformation out there. The first of these local ordinances started in Hazleton, Pennsylvania, which some of you may remember. Well, we had at the ACLU had a 3-week trial challenging the Hazleton law, and the justification for the Hazleton law was it's undocumented aliens are causing crime, are costing the city tons of money, are using public services. Well, we went to trial. Crime has gone down. The city has a surplus now. It used to have a deficit. The hospital is in the black instead of in the red. So all of the claims for why the law was enacted were disproven when there's an opportunity to actually interrogate the assertion.
So feel free to quibble.
So, pardon me?
I said feel free to quibble because it gives me a chance to maybe explain.
So the quibble part I want
too.
is to say that as to the Utah law, you know, the other thing that it does though is create a crime for transporting someone across state lines if there's a reason to believe that that person's undocumented, right? So that's another method by which a state is getting into the business of trying to criminalize or regulate who's in the state and who is. And I think that the stop and verify provision in Arizona, in Utah, while different than Arizona, has a different problem, which is that a person's subject to it unless and can't show the necessary identification unless the police officer decides that for that particular person it's not necessary, right? So it's kind of the reverse, which is to say if there's the risk there that if the person's white, then they'll be excused because the police officer has the permission not to enforce the law when they choose not to. There's a few other provisions as well. But the larger point that I want to make is that I do think, as you were saying, Mark, that the critical thing is that we hope that the appetite for these laws is diminishing, that the values that you're suggesting are exactly right. This is not the right way to address the problem. It's bad for communities, it's bad for public safety, it's bad for our nation as a whole, and that regardless of what the Supreme Court does, that the states that are tempted will realize that this is not good policy.
Thanks, and I do want to start with Mark next, just to address any comments that have arisen from the other panelists, but then to also talk about, to take head on, is there a way to do this that doesn't involve racial profiling? Mary Elena said that they can't be done without that, and I want to ask you about the assertion having to do with actually legislators writing laws, but also the police training issue, because that's something that's certainly going to be on the forefront in Arizona itself when the court rules.
But the police training issue and profiling isn't new. I mean, it's something that we've been dealing with in law enforcement for many years, obviously, and we've made a lot of progress. I'll tell you, most law enforcement, almost every law enforcement officer in this country does not want enforcement-only type legislation. They don't want it. You have one or two narcissists, I'm judge, jury, and executioner in this here county, but for the most part, they don't want it because they understand that we have made progress in the law enforcement community from the old days where it was stay in your house, lock your door, we'll keep you safe, to community-oriented policing, that public safety is best if you get in the community, if you know them, particularly at-risk communities, if you're in the neighborhoods, if you're working with people, if you're attaining the trust of people of whatever color, race, religion, demographic. That's what most law enforcement is about. And so we've seen the last decade, every single police agency should have, and in Utah they all do, all 110 PDs and 29 SOs, they all have very strict policies against racial profiling. We've instituted in our training, in our post officer standards and training and police academies, not just in your basic training, but requirement for in-service training. They're really trying to work on this. Is it still profiling? Yes. What we certainly don't want, and cops certainly don't want this bill so they can have another tool if they're bigots or racists and want to racial profile somebody. They don't want it because they believe it hurts their ability to keep the public safe, because you're going to lose a whole segment of the population. You're going to lose their trust. They're not going to look at you as someone they can rely on. You're absolutely right. People won't come if they're victimized. In Utah, since we do feel we have a responsibility to protect the public from undocumented aliens who come to our state to break the law, and they're the gangbangers and the ID thieves and the drug runners and the human traffickers, and there's some bad people that are violating state law, and we want to go after them. And so we formed what's called the Secure Strike Force. Nothing to do with secure communities. This is our own acronym, because we have some concerns about secure communities with the federal government. But we are very successful in just getting the bad. And 95% of our confidential informants are otherwise undocumented residents. I mean, they are working with us because they trust us, and we don't want to end that trust because it ultimately hurts public safety. So that's law enforcement in general. They don't want these laws. Yeah. They want alternatives. That's why you have Chris Burbank stepping up, chief of police there, and saying this isn't the way to go. And I think that's generally the case. And so while I know that it seems like it's easy to blame politicians or whoever, policymakers who may have a difference of opinion, are concerned about the rule of law in this country, and it is a rule of law. It's a constitution society. We are a rule of law nation. We have to have secure borders. We have to have laws and rules. And yet, if you have a different way of going about it, it doesn't help, I think, the debate in a progressive way to say, well, if you want these laws, then you must be a bigot or racist, or you don't like people of color. That is there. I get it. I have a lot of haters saying that I'm a traitor to my race because I'm out there trying to protect the Alabar sisters the other day from 7 days away from deportation, and gratefully John Morton stepped up in a big way and said, okay, we're going to stop that and allow them deferred action. And then what's going on today with this new policy is wonderful, I think. So and I get the hate mail, so I know that there is that, but not everyone is that way. They need to be educated as to the right. When you say it doesn't help you when you're running for the president and you have a wonderful program of in-state tuition for the children of undocumented residents like we do in Utah, and the only answer for that is, your only explanation is, well, if you don't accept that, you don't have a heart. You saw how far that got governor from Texas. There are good, reasonable law enforcement and other wonderful explanations as to why you have in-state tuition and pushing for a DREAM Act. But just to say, if you don't like it, it's because you don't have a heart or because you're a racist or whatever, that's not going to help move the debate forward. And so that's what we're trying to do in Utah. So in Utah, in addition to what we felt was a Arizona light or whatever you want to call it, and again, I didn't support it, but we're going to have something that's going to be, at least we can make it better than Arizona. And that is that we said the Republicans, reddest of red states, we're going to be progressives out there. We want to encourage the ability of people to work while they're here. Until the federal government gets their act together and fixes the problem, we have people in Utah who are working, and they're working under the table, and they're working in horrible conditions. They're being paid less than living wages. They're being mistreated, and they're using somebody else's social security number in order to work, and they're having taxes withheld and never get it back. I mean, let's do something that's, yes, arguably unconstitutional, but we give people driver's privilege cards in Utah. We go, you're driving, so might as well know that you know our laws, you pass a test, you have an ID, and you have insurance, which 86% of those who have driver's privilege cards in Utah have insurance. So why not let them work? You know, we're going to do a background check. If you're already working, you've been in the country a certain amount of time, you're working, criminal background check, you're not violating other laws, which the vast majority are not. You're willing to pay a fine that we can deduct from your wages because you did do something that was contrary to law, either overstayed or entered, and then we're going to let you work. We're going to let you work. We're going to keep your families together. We're going to let you work. And so I've been working for 2 years now to get the federal government to agree that we can do this in Utah. And yeah, you can't waive a federal crime of hiring an undocumented alien, but they can exercise prosecutorial discretion, and they can defer action on those who are working. That's what we're asking them to do.
Well,
Stacey, you want to respond?
I do, and I want to compliment Utah. I mean, they have actually done some things we would love to do. Our challenge is that we don't necessarily have a climate that our Republicans get to be as progressive in their thinking, and I mean that in a very sincere way. A big part of my job as minority leader is to, I mean, I kind of characterize it sort of sarcastically. A big part of my job is stopping stupid. It's not letting us do just really dumb things that are going to be harmful to the state. But an equally important part of my job is collaborating where we can and finding spaces where we can work together. And what I've been proudest of during my time as minority leader are the number of times we've been able to work together with the Republican Party to accomplish good things. We've done some remarkable criminal justice reform under our Republican governor. We've been able to not do dumb tax things, and we were able to shift it to a better tax policy. And so I do think some of the things Utah wants to do are incredibly important. The challenge is that we only care, I wouldn't say, I'm about to get myself in trouble. We tend to only like adopting the unconstitutional things that are problematic to the people I like, and not the other things that we think may be challenging to the Constitution. I actually think a lot of what Utah has put on the table makes sense, but we can't get a conversation started because, well, then suddenly we want to abide by the Constitution. But I want to agree with him that some of the strongest and most vociferous protests to HB 87 in Georgia came from the sheriffs and the police departments. They don't want to do it, but they know once it's on the books, once it's in your SOPs, you're then going to be measured in your achievements by whether you comply. And all you need is to not comply with the one guy who ends up being the one undocumented person who commits a terrible crime, and then your whole situation changes. And so there's an affirmative effect by having these laws on the books that forces people who otherwise would not engage in that behavior to do so. And that's one of the biggest challenges with laws like this. It takes away the exact discretion and community building that we've spent so much time trying to instill. You put a chilling effect on it because you say, if you don't, here are these other consequences. I think the other piece, and the truth-telling piece, I think, is also critically important that Mark raised and that Lucas echoed. There are very few places where there is proof that having undocumented persons in a community is actually costing you money. It's just not true. In Georgia, as in most states, we have all three of the taxes. We've got personal income tax, corporate income, so we've got income tax, sales tax, property tax. The people who pay the best compliance with property taxes come from people who rent, because they have no choice. They are the highest in compliance in property tax payments of any population. They pay sales taxes because I can't find a Kroger that will let me just walk out without giving them my money. The only piece that they don't pay with a degree of regularity is income tax, except for a lot of these folks, they have their taxes are taken out of their checks. And so there is a lack of honesty in the numbers that I think then leads to the sort of proliferation of bad information on both sides of the aisle about these issues. And I do think that there should be a space where Utah's laws make sense. But I think the other conversation is that we have to, as state legislators, put pressure on our congressional delegations to do something. We are making work for ourselves because we are too lazy to compel the people we elect to Congress to do their job. And that, I think, is the most important piece of my job, which is, unfortunately, most of my congressional members aren't from my party, so they don't listen to me quite as loud as I would like. But we have to push that. And the last piece I will add is that I think Utah has opened an opportunity that I would love to see ACS members take advantage of, which is that we need alternative ideas. I think he's absolutely right that saying no is not it's not an effective political strategy. I can be righteously indignant all I want, and then I become righteously irrelevant very quickly. And so there have to be alternative ideas, and those alternative ideas have to be generated by the very people who are upset with what's out there. Because Chris Kobach is winning because nobody is countering him. Utah has tried to come up with some alternatives, but you have to have a very specific set of circumstances for that to work. And so I do think there is an open space for better ideas that recognize that until we can get Congress to act, local legislators are going to act. Other states are going to do things. Mississippi has defeated the law twice, but it's coming back, and it's going to be worse the next time it comes back. So we do have to start putting something else into the conversation for legislators to offer.
I'm going to just one thing to have Maria Elena pick up on whether Chris Kobach is actually winning, because I've gotten a sense that there's been enough backlash. And so I wanted to ask you about what you're sensing politically in the states, and then if you would, just because of the time we're at, segue into the importance of today's announcement relative to the Dreamers.
So I think that you know, whether he's winning or not is still, I think, to be measured. But if you look at the whole attrition through enforcement policy, that's really about self-deporting, right? And as we've now heard, that has reached the national campaigns as well. One of our politicians who are running for president also is in favor of self-deportation, or at least that's what he was saying during the primaries. I'm not sure what he'll say now. You know, at the core of these, we are at a crossroads in this country. I mean, basically, it's a question about whether we're going to allow states and policymakers in particular to continue down a path of promoting policies that are based on fear and hatred, that are simply preying on individuals' economic insecurity, their pain, and their fear of others, their fear of people who look and sound like Stacey and me. Right? I mean, that's what this is about. Or are we going to go down a path in this country where we take back the country and really build on our diversity, build on our strengths, and engage in state policy that's really about economic prosperity for everybody in the states. Leave immigration policy for the federal government, because that is who is in the best position to do that. And both Stacey and Mark are absolutely right. We need to hold our congressional delegates accountable and ensure that they pass and enact immigration reform at the federal level. And it's because of that inaction that today the president has announced a policy from an administrative perspective to say, until we can actually get the DREAM Act at the very least, then we shouldn't be deporting these students that are trying simply to be their very best, contribute to the country in so many ways. Let's stop their deportation, let's give them work authorization, and allow them to contribute while we work on getting the DREAM Act. And so 2013 is going to be really interesting. The question is, if the Supreme Court decision in Arizona versus the United States is along the lines of what we've talked about, just because that's a Supreme Court's decision, it does not mean it's good public policy. We have many examples throughout our history. The Dred Scott decision is the one that always comes to mind in these days, where the Supreme Court simply was on the wrong side of justice. And so states are going to be looking at moving in a more, we're hoping that states will be moving in a more progressive, and again, that's with a small p, not about Democratic or Republican, policy. And we all, I think everybody in this room, and ACS and the National Immigration Law Center, ACLU, are looking at what are some of those creative policies that can help us get back on the right road.
Thank you. Did anybody else want to just add a line or two?
I want to talk politics real quick, because and to make this happen, at the end of the day, and I've been a politician, if you will, for 14 years, Republican politicians, they want to be reelected. Now, I believe most I've worked with, they're good, decent people. They believe in public service, but at the end of the day, they want to get reelected. And so when they start believing, after 1070 and Jan Brewer and suddenly Tea Party coming in and taking over my party and, you know, and changing, moving things to the right, they thought that's who the base was. And to be reelected, you had to pander to that side. So we lost great, moderate working senators like Orrin Hatch and John McCain, DREAM Act supporters, who suddenly are facing challenges or whatever, and they think they have to, their base has changed. What we're trying to do to make, the only way we're going to get Congress to change, Republican legislators start change, is to convince them that they're listening to the wrong people, that they are not the basis of our party. And so we think in Utah we're an example of that. I mean, there were Republicans, two-thirds majority, who had to stick their neck out, who were being told 1070 or nothing. And when they did something different, and whether it's ultimately constitutional or not, they did different things. They all had a huge target placed on their back. They were told, we're going to take you out of convention. And we have a convention system, not just a primary, convention where, I'll tell you, the extremes come out in force in convention systems because they have so much power, and they, you know, most people are up home mowing their lawn on Saturday. These guys want to get in there and argue till midnight. So they were going to take the governor out, Speaker of the House, to sponsor this law. We had our convention. Here's the good news. These senators and House members who stepped up and did something different and unique and comprehensive, who were targeted, have all survived the challenge. And in fact, those loudest supporters, the guys who were saying, Russell Pierce is endorsing me, these guys ran against the governor, they ran against others, every one of those guys lost. And that's a message that I'm taking to every, if I can, every state legislature in this country, and ultimately to Congress, members of Congress, and even to presidential nominees, that you're talking to the wrong people. You can do the right thing when it comes to immigration in this country, and you don't have to worry about losing your job. You shouldn't be, but you won't have to. You can be reelected. We have an example there. We think we can prove that. We're going to try and show it to everybody.
You want to come to Georgia?
We're down there. We were there this week in a conference trying to convince them.
Yeah, and let me know how I can help.
We're going to switch now into our Q&A portion, and we've got a couple people with microphones. So if you would just hold on a second until somebody with a mic gets to you. Right up here. We've got some up here. See? Right there. Thanks.
Hi, thanks. I'm Garrett Epps, and I just want to quickly ask the panel if you want to compliment. We started off by discussing how the Chief Justice said the racial profiling dog is not going to bark, right? In this case, there was another dog that really didn't bite and bark and wasn't really advanced on either side and was scorned by Justice Scalia, among others, which is the fact that this is a federal interest because it is so important for foreign relations. Mm-hmm. And the only discussion I heard in that room was when Scalia said, oh, now we have to enforce our laws so Mexico likes us, to which I thought really might have said, yeah, right? But I wonder if people want to talk about the kind of foreign policy implications of this at all.
Thanks, Garrett. Does somebody want to take it on? And then we've got other questions, too.
Let me just say very briefly, I think it's a critical point. It's what underlies why the Supreme Court has repeatedly said that immigration policy has to be federal, because it necessarily implicates foreign relations, is directly part of the national foreign relations power, going back to the harassment of foreign nationals and so on that I mentioned. And in fact, a bipartisan group of former State Department and foreign policy officials filed a lengthy amicus brief in the case, Republican and Democrats, making exactly that point, that this is critical to foreign relations. And it's not about Mexico exercising a veto. Let's just be clear about that. That was a nice, little rhetorical point that Scalia maybe wanted to make. It's not about whether or not a foreign nation has veto authority. It's what the U.S. foreign policy is with regard to its decisions about what's in our foreign policy interests with regard to foreign nations. Mm-hmm. And what the United States has said is that this is inconsistent with our national foreign policy interests.
Thanks.
But you're right, it didn't get made much of.
Yeah. Right behind Garrett, there.
So I want to look forward past U.S. versus Arizona and ask this, maybe make the statement and ask the panel to react to it. Probably the best case scenario for people in this room is a 5-3, at least a 5-3 decision for the United States. But maybe I disagree with Lucas in that I'm not sure that the appetite for this sort of legislation would be in any significant way diminished even with that result. And I want to suggest that for the following reasons. One, as the panel pointed out, Plyler versus Doe decided 30 years ago. Despite that, you had Proposition 187, AB 56, which fly in the face of any reasonable reading of Plyler. Two, you had, as you pointed out, Alabama's HB 56 has a slightly different provision, a more extreme provision. You can go around the country, and they're not, while they're all based in sort of model legislation put forth by Kobach and Early, they're all slightly different, so it's not clear what effect U.S. versus Arizona actually has on any of those laws. Third, to the points that were made at the end by the Attorney General, the politics of the proliferation of these sorts of laws suggests to me that you're likely not going to be diminished even if you have a 5-3 ruling in favor of the United States, mostly because it's a well-funded campaign. You have Numbers USA, FAIR, Michael Hetman, Chris Kobach, Early, proliferating these laws in politically receptive jurisdictions. And four, I don't think, I'm not as hopeful as perhaps the Attorney General with regards to seeing any sort of federal legislation, because I don't think that there's any possibility in the near future of getting bipartisan support. I think that is encouraging what you mentioned about the Utah legislature, but if you look at the last 7 years of congressional proposals. DREAM Act is supported by a majority of Americans, yet you found no bipartisan support each time it was introduced in Congress. No possibility, in my estimation, that in the very near future you would get any type of reform other than enforcement-only, restriction-only type of thing, which is why you see the administration having to take executive action as opposed to congressional action on many of these issues.
Marilena, do you want to?
Sure. So a couple of comments. One is, so I think you're right. If we look at 2013, I do expect, and I think several of the panelists said this, we expect to see many more of these. There's no doubt about that. And the question is, will they be narrowly tailored to be flowing from the Supreme Court decision, or are they going to continue to try to just expand and push the envelope, which is frankly what they've tried to do? I mean, early in all of these proponents, their strategy has been not just to pass and not just to actually enact law, but they're introducing bills that will help shape the debate, very much from a toxic perspective of for promoting some of the myths that Mark was talking about, right? Just pure out lies. And so their interest has been, their interest is a long-term interest, long-term strategy to really, again, force people out of the states and hopefully force people out of the country. And they have a very restrictionist vision. And so we will continue to see many, many more reiterations of anti-immigrant, for lack of a better word, anti-immigrant, racial profiling laws, et cetera, with new models that we'll have to keep fighting against. I do think that the Whiting case and what happened in 2012 this year is an interesting development. So when Whiting was decided last fall, we thought that was the green light, and in fact, it was a green light to the states, and we thought we were going to get tons of mandatory E-Verify laws at the state level. 27 states introduced legislation this year. Not one passed. Okay, and I think the reason for that is manifold. One, probably many of those states were looking at the Supreme Court, but in fact, they could have simply approved those laws because Whiting gave them the green light. But second, we actually engaged in a really broad, non-traditional coalition to fight those bills, including working with libertarians, including with the Tea Party, where we were actually aligned against this. The Tea Party sees mandatory E-Verify as big government and opposes it for that reason. And then lastly, the economic reasons, and we can't forget that. I mean, Stacey explained from HB 87's perspective what the impact was in Georgia and throughout the migratory trails, but mandatory E-Verify and all of these laws have such an economic impact on both local communities, the statewide, and the country as a whole, that's another reason why some states may actually decide not to follow suit.
Can I give a little backstory? Because we're not just sit back and hoping, well, they'll look at Utah and say, wow. No, it has to be a very organized. Marilyn is exactly right. I mean, coalitions are key. And what we've done, and in fact, the backstory on what happened in Utah, seeing that we were having this headlong rush to copy Arizona, was we had to change public perception to get those people talking to the legislature, showing polls that turned the tide. And so we did what we got our groups together were law enforcement, faith-based communities, and the business communities, in addition to all the other great advocacy groups that have already been fighting these battles. And for several reasons. One, because we could see and we knew already from Arizona in less than a year the economic impacts. We had corporate America, Chamber of Commerce, industry, corporations, all those that are impacted coming in and joining our coalition, and we passed a thing called the Utah Compact. It was a very one-page statement of 5 principles that whatever you do on immigration, you should follow these basic principles. And that's what turned the tide, because every member of the legislature was of one faith or another. They all like to wear their pins that say, "Oh, I support law enforcement," and I guarantee every one of them likes to get campaign donations from the corporations and businesses out there. And they're also concerned about economy and balancing their budgets at a very difficult time when we're all coming out of this recession and state deficits. So with that group together, we did that. And so now we've taken out the Indiana Compact, an Iowa Compact, and the other states are looking. Alabama, they're talking about, let's do an Alabama Accord down there. Let's get these same groups together, because those are the ones who are going to show and give courage to primarily Republican legislators and hopefully members of Congress ultimately, as this grows around the country, to do something different and better. We just held the Southeast Conference in Atlanta this Monday. We're going to have a Midwest Conference, and we're going to keep pushing this idea forward with that growing group of people who haven't really necessarily been involved in the past. They've been that more silent majority.
Thanks.
I think there's success.
Another question right there.
Sure. Thanks. So I'm really pleased with the Obama administration's announcement today about their attempt at implementing the DREAM Act. But I'm kind of wondering that earlier on this administration, when the administration came out and said that they were going to stop enforcing medical marijuana laws in states that had passed medical marijuana laws. U.S. attorneys kind of did a backlash against that. I'm wondering, to what extent can U.S. attorneys kind of stop this DREAM Act implementation from coming, or what do you guys think will end up happening?
So I guess just to clarify, first of all, it's not an administrative DREAM Act, right? Because it does not provide a path to citizenship in any way. It really is simply about preventing people who are currently in deportation proceedings from getting deported if they meet the criteria, and secondly, ensuring that any individual who does meet the criteria for the 2010 House bill, which passed the House, that's the criteria that's being used for this, that they can go affirmatively to the U.S. Citizenship and Immigration Services and apply for deferred action with work authorization, which again is just a huge, huge victory. The last thing, I think what you're suggesting, I mean, we've seen it in the immigration context last year when Immigration and Customs Enforcement announced that the administration was going to start using their prosecutorial discretion and not deporting people who were low level, who are low priority for that. Unfortunately, it was not enforced. I mean, it's only less than 2% of the cases have been administratively closed. The administration backpedaled, and they said they were going to provide work authorization. They did not. And at the local level, immigration agents have, because it's discretionary, basically decided they weren't going to exercise their discretion. So that is a concern. In fact, I had a conference call with Dreamers this morning at 7 in the morning, and they're cautious. I mean, they are very happy, but cautiously optimistic because of that as well. So that means from the advocacy perspective, we will need to continue being very vigilant to make sure that this is actually implemented in the way that the administration is saying it will be.
Lucas, you want to
I just wanted to add, I think implementation is absolutely critical, to underscore what Maria Elena said, because the policy on its face is very positive, and the implementation is essential. And with respect to that, I would urge Mark and other Republicans who share his views, the law enforcement community, the education community, but especially the Republicans, to endorse this, to applaud the initiative, so that instead of there being...
Hey, my quote's already out there today supporting it. In fact,
I think that's great, because that's what's critical, and that's what's going to matter in terms of how this is implemented, how meaningful it is, and whether further steps can be taken in a positive direction.
Stacey, did you want to add something?
Well, I would say that the political reality is, depending on the outcome of the election, it's an executive order that can be rescinded in 2013. I think that given the current temperament and climate, you're going to see an aggressive implementation option used by the Obama administration, because it's going to help a lot. And so one thing that I think on the other side of the aisle, in addition to the work that I think Mark has already put out there, it's also making certain that on my side of the aisle that we're also not only applauding it, but that we are helping to make sure that we are pushing enforcement. Because it's easy to do something big and forget that you've done it. And one of the options that we have, even if you're in the minority in a lot of the states, is to make certain that you're keeping those stories out there, that you're pushing the conversation, and that the minute you see something not going right, that you let somebody know so we can kind of push it. Because the worst thing is to have a bad story in October about how this didn't work. And so I do think you're going to have, there's a very strong political element to this that I think will make it stronger than medical marijuana, which is not exactly a voter turnout issue.
I think we have time for one more question. There's one up here. Thank you. Was there one back there? Oh, okay, good.
Hi, I'm John Garment. I teach at Faulkner University in Montgomery, Alabama, and this is actually one of my students. From the inside baseball common law perspective, if the administration has the power to do this today by executive order, why haven't they put out an express preemption statement either by executive order or by notice and comment rulemaking by DOJ or DHS? Would that work? And if it would, why haven't they done it?
Just to clarify, the announcement today was not by executive order. It's simply administered by the Department of Homeland Security. And they've had this authority to do so for years. Go ahead, Lucas, you can try the preemption.
Well, so I think you're raising a really interesting and important question, which is, and this goes really back to the Whiting case, could the executive branch have done more to bolster its argument with respect to federal preemption? I think the answer is absolutely yes, by regulation, by executive order, by other kinds of pronouncement. It could have dealt with an Office of Legal Counsel memorandum issued back in 2002 that reversed an earlier Clinton interpretation OLC memo on the so-called inherent authority of the police the OLC memo issued by the Bush administration in 2002 that is mistaken, that reversed, as I said, this earlier policy that's created difficulties for the federal government's position to try to reconcile its views. So there's a lot of things that the administration, in my view, could have done to bolster its position that would have made a difference. I cannot answer the why question. Everybody in this room can answer that better or than I or for themselves. You know, I don't know, but I think it's unfortunate because given the federal interest, the executive branch could have done a lot more, and in my view should have done a lot more. But
Did you have a follow-up back there? Wait for the mic. Do you mind?
I think that in this case, the
What?
preemption standard would have to come from Congress, not the executive branch.
Could you repeat it?
I think that in this case, the preemption statement would have to come from Congress, not the executive branch, and that a statement from the executive branch that they thought that it was preempted would have absolutely no effect.
well, so just not. I mean, this is great because these are the kinds of discussions we should be having here.
Yeah.
But I think there's a difference between a statement and the kinds of policy initiatives, regulations, and other matters that the executive branch could have done with regard to particular statutory provisions and with regard to how the Immigration and Nationality Act vests authority in the executive branch. That's what it does. And the question is how the executive branch implements that statutory authority, which is what where Congress has spoken. But we should.
And I suspect there'll be especially from Republicans in Congress, a huge backlash to today's announcement, and they'll start claiming they can't do it. Another example of acting beyond the Constitution. But I will say, as a law enforcement official most of my career, and I was talking prosecutorial discretion with DOJ and Homeland Security 2 years ago now. They absolutely have the right to exercise, and they have to, in fact, the responsibility to exercise their prosecutorial discretion and use their limited resources that they have in the areas that most are going to affect those who are here in a danger, and leave alone those who are here and who are actually contributing to our society.
That's right.
Thank you. This was a great way to celebrate 30th anniversary of Plyler and the announcement.